everybody, Brett Thompson with Thompson Law Group. All right, we're going to do another Teaching Tuesday, another Closing Ninja Classroom. Today I want to talk about different kind of warranties that can come along in a deed, all right, from the seller, also known as the grantor on the deed. So the highest and best, so we're going to go from best to worst here. The highest and best type of warranty is called a general warranty. So on a general warranty, the seller, known as the grantor, is saying, hey, I'm going to warrant the title to the property, meaning that I will defend your right to the title all the way back in the chain of title. So I'll defend it against anybody. So I will warrant the title and defend it against anybody that were to have an adverse claim to your claim to title, to your claim to the ownership. Now, very often in a general warranty deed, also you're going to see what's called English covenants of title. And there are 4 English covenants of title, and that kind of just spells it out in more detail and more specifics what the warranties are. So number 1 is the right to convey. So this warrants that, hey, I have an absolute right to convey the property as the seller. I don't have to get permission from anybody else in the world in order to convey my interest to you. Number 2, quiet possession and free from encumbrances. All right, so quiet possession, that doesn't mean that your neighbors are not going to have the music up loud, okay? Quiet possession means that you have the right to possess the property and nobody else can make a claim, such as through a lease or whatnot, to possess or have an interest in the property other than you. So you can quietly and peaceably possess the property. Free from encumbrances. This covers a number of things. This is encumbrance could be mortgage liens, judgment liens. It could be easements, any kind of encroachments, tax liens. So it's saying that there are no encumbrances that would adversely affect your title ownership in the property. Number 3, the third English covenant of title is further assurances. So as the grantor, the seller, they're also saying that, hey, I will give you further assurances, meaning that if something came up and there was an adverse claim and I had to sign another deed to clarify or to correct the prior deed or another document to further assure that I have conveyed you fee simple ownership interest in the property and that you own the whole thing and you have general warranty, I will make those further assurances in any document or any act. If you got sued, I could come in and defend your right if the suit was about the title ownership of the property. Number 4 is the no acts to encumber. This means that the seller has also not taken any proactive steps that could encumber the property, such as agree to grant an easement on the property, or the seller didn't go last week and sign another contract for the sale of the property to a second party. Therefore, they could claim an interest in the property as a contract owner. So these are the general warranty and the English covenants of title. That's what you want if you're the buyer. You want to have that in your deed. That's the best assurance and the best warranty you can get. A special warranty deed would be next in line here. A special warranty deed basically says that, hey, during my watch, during the time that I own the property, I haven't done anything that would adversely affect your title ownership of the property. So I'm going to convey it to you, and during my watch, I haven't done anything to screw the title up. It does not make any warranty for anything that happened prior to when I owned it. So prior in time in the chain of title, I'm not going to warrant against any claims that may have arisen before I took ownership to the property. So it's not as good as general warranty. Now, a quitclaim deed is no good, okay? A quitclaim deed basically says, hey, if I own the property, if I have any ownership interest in the property, you can have whatever ownership interest that I may have. So it doesn't even warrant that you own the property. So it doesn't even guarantee, if you will, that the seller actually owns what he's trying to convey to you. So a quitclaim deed simply says, hey, if I own any part of it, you can have this part that I may or may not own. No good. Now, I threw in deed of gift down here at the bottom. It's not a warranty, okay, but I get a lot of questions about a deed of gift. A deed of gift simply says that there's no monetary consideration for the transfer, meaning that it's not a taxable event. All right, if there was monetary consideration, you'd have state and local transfer taxes, known as a grantor's tax and a grantee's tax. A deed of gift is giving the property away. Okay, it's a gift, so there's nothing of value in exchange for the conveyance of the property. In a deed of gift, you can deed of gift it via general warranty, special warranty. You can quitclaim deed of gift it as well. It simply says there's no monetary consideration for the transaction. So if you are a buyer, you want a general warranty, okay? The next in line is a special warranty. You're probably going to see a special warranty if you buy it from a foreclosure trustee or from a bank, or from an estate, okay? Because they don't want to expose themselves to liability, anything in the past, all right, in the chain of title. So that is warranty deeds in a nutshell, okay? That's a very summarized version of it, but I wanted to add a little value to your lives today. Thank you. How long was it?